This conference will now be recorded.
All right, I think that means we're ready to get going.
Yeah, yes, it is. It is 12 o'clock on the East Coast, so we are going to go ahead and get started. Hello, everyone. My name is Jessica Enix, and I'm with the ASA staff, and I would like to welcome you to today's ASA webinar. Before we begin, I would like to review a few points of protocol so that you'll get the most out of your webinar experience. Remember, you are listening to the webinar via a conference service. If you are disconnected, repeat the steps that were given to you in the registration email. In order to reduce background noise, please mute your microphones during the presentation. If you have any questions during the presentation, please type them in the chat box. The chat icon is located at the top right-hand side of your screen. Our presenter will address questions as they become available or at the conclusion of the session. Please note that today's program is being recorded and will be available on the ASA online website at the end of the day today. Now it is my pleasure to introduce our presenter, Mr. Mark Felizzola. Mark Felizzola is a shareholder in the litigation and construction services groups of Babson Calland. He has extensive experience in cases involving the Pennsylvania Mechanics Lien Law, Commonwealth Procurement Code, and the Contractor and Subcontractor Payment Act. Mr. Felizzola serves as outside general counsel for construction companies and frequently represents clients in a variety of commercial and construction-related disputes, including product liability claims, asbestos-related claims, construction bid protests, construction defect claims, differing site condition claims, delay and inefficiency claims, payment and performance bond claims, and payment and contract performance disputes. Mr. Felizzola has litigated before the Pennsylvania trial level and appellate courts, the United States Federal District Courts for the Western District of Pennsylvania, the Northern District of Western Virginia, and the District of New Jersey, the American Arbitration Association, and other private dispute resolution forums. We also have Mr. Benjamin Wright. Benjamin Wright is an associate in the construction and litigation groups of Babson Calland. Mr. Wright has experience in cases involving professional liability claims involving architects and engineers, as well as both general contractors and subcontractors. He has handled a wide range of construction disputes and issues for natural gas refineries, schools, churches, parking garages, and residential homes, including disputes regarding delay, payment, change orders, differing site conditions, acceleration, and inefficiencies. Ladies and gentlemen, please welcome Mr. Mark Felizzola and Mr. Benjamin Wright.
Thank you, Jessica. As Jessica said, I am a construction attorney in Babson Calland's construction and litigation groups. My practice is primarily in the Pittsburgh area and the Western Pennsylvania region. And I recognize that most, if not all of you, are likely from someplace else in the country. So the information that we're going to be going over is going to be general and not necessarily specific to your jurisdiction. So as with everything when it comes to your subcontract, your best bet might be to reach out to your counsel to confirm that, well, this will be or won't be enforceable in our jurisdiction and things like that, to the extent that you're not already aware. So with that said, let's get into it. Today we're going to be talking about form contracts and recommended areas of modification or areas where there may be some opportunity to shift risk, or frankly, more likely where contractors are likely trying to push risk unfairly onto the subcontractor. Obviously, this is for the American Subcontractors Association, so we're going to be talking about this all from a subcontractor's perspective. We are focusing on form contracts because they are the most common in the industry. Obviously, the type of information that we're going to be talking about here is equally applicable to a non-standardized contract that you may receive from a contractor as well. The information, while we may say it's in this section of the AIA or this section of the consensus docs, it's probably somewhere in your contract, even if it's not a consensus doc or an AIA document. So hopefully, regardless of what contract, or I should say what subcontract you're looking at, hopefully this will still be applicable and you'll be able to get something out of this. So with that all said, In this presentation, we're going to cover what you should be looking for when reading a proposed subcontract, what you should be considering when reading the key provisions, and how you should try to protect yourself as best you can in a subcontract. So generally, before we get into the nuts and bolts of specific areas, at the beginning of your subcontract, there'll be what I generally refer to as a preamble, where it's going to lay out the general information specific to that project. So you want to look at that and make sure it identifies the parties accurately, and in particular identifies your business name. You know, a lot of companies have a doing business as name, or they drop the Inc. or the Corp. Or the LLC, and just refer to themselves as, you know, ABC Masonry. But for purposes of the contract, it's important to make sure that your full legal business name is included in the agreement. It just is a nice, easy thing you can do. You're not going to get any pushback on it, but you avoid any issues down the road of, well, I was really doing business with the president and his individual capacity. There's no ink here. You know, it just nips those types of things in the bud, so you don't have to worry about them. And there's no reason not to do it, because you are doing business as your business. And so just make sure that's reflected accurately. This next one, identify the owner accurately. This is going to be much more difficult for you on the front end if you're a subcontractor, because oftentimes you don't have the full picture on the owner. But where you can really get into trouble here is if you work on a project and the contract documents say it's owned by, you know, XYZ Corp, and then you go to file a mechanics lien. You can't just refer, if you haven't confirmed on the front end that your owner information is accurate. On the back end, if you do need to lien the project, you need to be really careful, or your attorney needs to be really careful in understanding exactly who the fee simple owner, or who the actual owner is of that property. So that way, and it might be that you're not dealing with the owner, you're dealing with a leasehold, you know, a tenant that has a lease interest or some interest less than the full ownership of the entire parcel. But that's the type of information that you need to know at some point, and to the extent you know that it's not right at the beginning of the project, and when you're getting into it with the subcontract, obviously you want to make sure that gets corrected. You also want to make sure you're identifying the project accurately, so that in the event that there is a dispute at some point in the future, there's no doubt that this subcontract applies to that project. And then the last thing, oftentimes in your preamble, you'll have information that gets to your start date, and you just want to make sure that this is clear. You know, are you starting? Sometimes, unfortunately, it's not best practice, but you may have already started work on the project. But you want to be clear. Is there a notice to proceed that will issue that triggers your obligation to start work? Are you entitled to start work and authorized to start work as of the date of the contract? Is it within so many days after? You know, whatever. It's just something to make sure you're paying attention to. And sometimes you'll find it's in the beginning of the subcontract in the preamble. So getting into the form agreements, today there are many different types of form agreements. Today we're focusing on two in particular: the AIA A401, the 2017 version, which is the most current version, and the ConsensusDocs 750, the 2017 version, which is the most current version. For those of you who are not familiar, the AIA updates their agreements every 10 years. So every AIA document will have, it'll be AIA, and then A is for construction, B will be for design, professional contracts, et cetera. And they have different letters for different types of contract by, you know, who the contracts are between. And then they have a number, and then they have a dash and a year. And then that year, every 10 years, the agreement's taken out, dusted off, and updated. So currently, the most current AIA subcontract is the A401, and it was last updated in 2017. ConsensusDocs is a little different. The ConsensusDocs, they update their agreements every 5 years. They do a full update, but they also update on an ad hoc basis. You know, certain portions they may say, well, this is a little out of date, or this isn't completely in line with what we're seeing. So they might change a term here or there, but every 5 years as opposed to every 10 years they do a full update. So we are also looking at the ConsensusDocs, the 2017 update. There may be some additional updates in the ConsensusDocs because it is kind of rolling for certain provisions. But generally today, when we're talking about an AIA document, it's the 2017 401 or the ConsensusDocs 2017. A little bit of background, the AIA documents have been published by the American Institute of Architects. They've been promulgating construction documents for the construction industry to use as forms for over 100, so it's over 115 years. And like I said, they go and they update every 10 years. The AIA agreements, at least in our region, they seem to be the most commonly used agreements by far if you're using a standard agreement. And they do have endorsement and buy-in from several trade organization and industry stakeholders. However, when the AIA went to go do their 2007 revisions to their most standard agreements, including the A401 subcontract, a number of trade organizations that had already either said the AIA is not really fair anymore, or and started just using their own documents, or had subscribed to the AIA and endorsed it for a number of years. They all kind of got together and they said, look, the AIA is no longer industry standard and what we believe is the consensus for the industry in terms of what the standard terms of an agreement should be. So that those organizations, and there were about 40 of them, got together and formed their own coalition to create what they believed was a more accurate industry standard agreement, and that's what the ConsensusDocs are. The word consensus is not a coincidence. It's because it is a consensus. It's intended to be a consensus of the stakeholders and trade organizations in the construction industry. And among those organizations that have signed off on endorsing the ConsensusDocs are the ASA, the ABC, and the AGC. So it really is a consensus of the industry, and they are good agreements. That's not to say the AIA is necessarily a bad agreement. They're both better than probably what you're getting from a contractor if it's not a standard agreement. It's going to be more fair for you. And for that reason, as we get into the actual terms of this, keep in mind that oftentimes a good strategy in negotiating, if you have to compromise somewhere, is to just take out the ConsensusDocs or the AIA and look at what that says about, for example, termination or for whatever, and go back to that and say, look, this is industry standard. This is what everyone agrees is fair. You know, you want this, I want that. Let's compromise. Let's just go back to the original, or go to the industry standard. So keep that in mind when you're negotiating. A perfect example of this, we'll get to it, is indemnity. I often, like, if we're negotiating back and forth on indemnity, it's a perfect place where you can say, look, let's just go to what the industry standard is in the ConsensusDocs or the AIA docs. So that's a little bit of background on the two types of agreements, or the two organizations. So once you start looking at the document, the subcontract itself, you have to recognize, and I'm sure everyone's aware of this, these are not standalone agreements. The subcontract, by its nature, incorporates a litany of other documents, and those are often referred to as the contract documents or the subcontract documents. And it's really important to understand the entire universe of documents that will make up your subcontract. So in the AIA A401, your subcontract documents are addressed in Articles 1 and Articles 15, and they do not include your proposal as a subcontractor or your bid. They do incorporate your prime contract, and they do require contractors to provide copies of subcontract documents to the subcontractor prior to execution. All of those are really important to know about. Number one, not having your proposal, and let's talk about the ConsensusDocs. ConsensusDocs addresses articles, what subcontract documents are in Articles 2.4, 2.6.1, and 13. They also do not include the subcontractor's proposal. They do also incorporate the prime contract, and they also They require a contractor to provide all subcontract documents prior to execution, and they do contain an express order of precedence. And I just saw a question come in here. What if the owner in the GC redacts key information in the prime contract? It depends on what they are redacting. It is, and it also depends on, to some extent, if you're working on a private project or a public project. But if you're working on a private project, oftentimes what you'll see them trying to redact is pricing information. And I'm okay generally if they want to redact the price information. But really, when you're looking at the prime contract, the information that's most important to you will be the payment terms, so you understand how soon after, when the contractor has to submit its pay apps to the owner, how long the owner has to review and make payment on those pay apps, how much time the contractor has or how to submit a claim. It's a really short notice requirements with respect to delays, inefficiencies, or change order claims and things like that. What type of waivers is the contractor making up front with respect to rights that it should have? How onerous are how bad of a deal really is the prime contractor striking in terms of taking on more risk than it should? And those are the types of things that really are not the prime contractor or should not be redacting. You need to see all the key legal terms. If they want to keep the financial stuff from you, that's generally okay, from my perspective. But when you are talking about subcontract documents, so it's really important, if you can, to try to get your bid or your proposal incorporated into the subcontract as a prime contract, as a contract document. And why this is so important is because oftentimes in your bid or in your proposal, you have exclusions and clarifications that qualify your price and your scope. And you need to make sure that those are working their way into the agreement. And the easiest way to do that is to make sure your proposal becomes part of the agreement. You also, if you can, in a perfect world, if you have all the leverage and you can really dictate the terms, not only do you want your subcontract bid or proposal to be incorporated, but you also want to establish an order of precedence that makes clear that if there's any conflict between your proposal and any other contract document, your proposal will control. Now, I recognize this is not a perfect world, and oftentimes you won't have the leverage to accomplish that. But at a minimum, if you can get your proposal in as a contract document, that's better than not doing so. And if you can't, then you need to be really careful with respect to the contract documents that do define your scope, wherever it's laid out in the subcontract, and that your clarifications and your exclusions are being carried through and made part of the actual subcontract. With respect to prime contract incorporation, you've got to be careful that you're not agreeing to be bound to the portions of the prime contract that you haven't seen for the reasons I already went into. You need to know what that prime contract says and what the contractor's obligations are to the owner with respect to notice and with respect to other portions of the agreement, and also what the payment terms are, so you can understand what your cash flow should look like, and so you can understand, oftentimes your obligation to submit a claim in a subcontract will be triggered not by a particular date or a particular number of days, but within a certain amount of time of the time that the contractor needs to make the claim. So you need to have that information to make sure that you are cognizant of the lay of the land on the project with respect to financials and claims and things like that. It's okay for those agreements to get incorporated, but you only want to incorporate it to the extent it's been provided, and you want to make sure that you are being provided those agreements. Alternatively, if they won't provide them to you, or if you're just not comfortable incorporating them, what we always do is we try to get language in there. The prime contract's incorporated to the extent it's been provided by the subcontractor, prior to subcontract execution, or something like that, to kind of protect against you being bound to things that you've never known about and that you've never been provided an opportunity to review. And then with respect to order of precedence, we've touched upon that, but an order of precedence section saying your proposal controls over all others, drawings, control over specs, whatever it is, it's better to know that and understand that. And if you have a preference, obviously, you want to try to make sure that that's expressed clearly. If nothing else, you want your subcontractor control over any conflict in the prime document. Yeah, so here we touched on all this. Ensure your proposal is included. Ensure that you've incorporated documents, the incorporated documents are the ones you've been provided. Ensure you review the most important provisions of the prime contract and ensure you know the order of precedence. So the next section or topic I wanted to cover is the contractor's responsibilities. These are addressed in Article 3 of the A401 and Article 4 of the ConsensusDocs 750. So here are your key considerations. Specifically, in this article, they will identify the contractor's representative and the scope of authority they have for the project. And it's really important that you understand both who the representative is that has the authority to bind the contractor and also what the scope of that authority is. Because oftentimes you're dealing with a superintendent or someone in the field, and if that person is not the person who has the authority to agree to a change in the scope or to authorize, sign off on extra work tickets or confirm something, I can't tell you how many times we've had a client come to us with that disconnect, and the contract says it's the project manager. The only person who has authority to authorize a change in scope is the project manager in the contractor's home office, and the entire time, the entire project, the superintendent in the field's been saying, yeah, I know it's extra. Yeah, you're going to get paid for it. Yes, yes, yes. And the project manager at the end of the day says, no, no, no. So it's really important you understand who has the authority. It should be set forth in the contract, in the contractor's responsibility section. And if you're in a situation where you're getting, you're looking for an authorization or you're looking for direction, you need to make sure that you are tying it back to who has the authority to direct you to make a change or to do something other than what your contract appears to require. You also want to make sure that the contractor's communications and obligations are set forth in the contract and that it's clear. This is especially important when it comes to subcontractor lien rights, and it's also important when it comes to making and passing through subcontractor claims. Because unfortunately, and I'm sure everyone's been in this situation, you're in a situation where you've got a claim for a delay or you've got a claim for something that's really needs to be pushed up to the owner. And if the owner's not coming, and because there's the chain of command, you can't just go directly to the owner and say, hey, I'm running into this issue. You have to push it up to the contractor, but you have to understand what the contractor's obligations are to push that claim forward, and then you have to make sure that that is happening. So it's an important section of the contract to make sure you're aware of. This area will also clearly outline the requirements for storage and laydown areas on the project, and I'm not sure how much leverage you're going to have with in terms of negotiating that, but you need to make sure that it's laid out clearly in the contract, and that if they tell you, yeah, you're going to have this area, that the contract says you have that area. And then this will also outline responsibility for scheduling and for coordination. And the most important part here is with respect to coordination. The coordination should be the contractor's responsibility. Obviously, you have to cooperate with the coordination, but to the I can't tell you how many times I've seen subcontracts where a contractor tries to say, it's your responsibility as the subcontractor to coordinate your work with all of the other trades, and that's not fair. That's not the way it works, because you don't have any leverage. Contractor has a leverage over the other subcontractors because they're the ones who control the payment, and they're the ones who have to be responsible for coordination. The same goes for scheduling. You have to make sure that you have a right to provide input with respect to the schedule, and that you're providing your durations, and that the contractor has to get your approval for changes with respect to your durations and your schedule. But the ultimate overall project scheduling obligation has to be on the contractor. Payment is obviously a very important term in the subcontract. It's addressed in Article 11 of the AIA and Article 8 of the consensus docs. And the biggest and most important thing here, and this is really jurisdiction specific, because there may be some of you who are in jurisdictions where pay if paid language is not enforceable, void as against public policy. But in the jurisdictions where I primarily practice, pay if paid is enforceable. For those of you who don't know, if there are any out there, pay if paid is sometimes referred to as conditional payment language. It's the type of language that says that the contractor's obligation to pay the subcontractor is expressly conditioned upon the contractor's receipt of payment for the subcontractor's work from the owner. That type of language, to the extent it's enforceable, and it is enforceable in many, many jurisdictions, could be completely catastrophic to a subcontractor, because it can, completely destroy your cash flow, and it can result in you essentially financing the entire project, or your portion of the project. And it's something that obviously you want to keep out. And if you can't keep out, there are some strategies to at least try to address and minimize the impact of. So first and foremost, obviously, if you can keep it out, you want to keep it out. You want your payment term to say you'll be paid within 7 days or 14 days, or however many days of receipt of your invoice. Short of that, if you're getting pushback, the next best compromise is, at least in our jurisdiction, there's a distinction between pay if paid and pay when paid. Pay if paid, remember, requires makes payment by the owner to the contractor an express condition precedent of the contractor's obligation to pay the subcontractor. Pay when paid, on the other hand, just says the contractor will pay you when it's paid by the owner, and there's no express condition precedent language. And the courts in our jurisdiction, and I believe in many other jurisdictions, have interpreted that pay when paid language to just require payment within a reasonable amount of time. And what's reasonable amount of time obviously differs based on the circumstances and the jurisdiction. But the key is you are entitled to payment for your work at some point, regardless of whether or not the owner has paid the contractor. It's just a matter of when, not if. So if you can't get pay if paid out entirely, try to make it pay when paid. And it's really almost an art of softening the language and eliminating anything that says express condition precedent. And sometimes you're able to get that done. Short of that, another really important provision that ties into the pay if paid that we're going to talk about later is the termination right. So if you are being forced to agree to pay if paid language, one of the key areas where you really need to push back is your right to terminate or suspend work due to non-payment. And you kind of need to tell the contractor you can't have it both ways. Either, if I'm going to have to work regardless of whether or not I'm being paid, I need a mechanism in the contract to allow me to stop working, either by termination or suspension or both, at some point, so I don't have to just work endlessly for free. And the way you sort of push that to the contractors, you say, look, this is for both of our benefit, because it gives you the ammunition to go back to the owner when the owner's not paying you and say, look, you need to do something here. You got to get this off center, because all my subcontractors are going to stop working and the project is going to grind to a halt if you can't start making these payments. So if you kind of explain it to the contractor that way, we found that you can get some more leverage and some more traction in terms of at least getting a termination right or a suspension right into your contract if they're going to insist on pay if paid. The other thing that we've had some success doing to kind of take some teeth out of this pay if paid is make it a conditional pay if paid. Pay if paid for so long, but if the reason that the contractor is not being paid has nothing to do with the subcontractor, in other words, if it's not your fault in any way that they're not being paid, then they have an obligation to pay you within X number of days or whatever. And getting creative with the language, and if you can work with your attorneys, I'm sure they can help you, or if you don't have one, we can help you try to get that type of language together to offer as another way to compromise to get this pay if paid language out of there. But there are some strategies short of just, well, take it or leave it, pay if paid, to try to work out in a compromise with the contractor. Another couple important things here, in both agreements, you have the obligation to provide a schedule of values, and then this should be no surprise to you guys. You bid, you bid, you submit your schedule of values where you break your price up, assuming it's lump sum, based upon the items of work, and then you bill based upon percentages complete during the payment period, or during the prior payment period, and that's how payment's done. It's the same under both types of agreements. Neither agreement contain as standard pay if paid language. So again, this is an area where if they're pushing, they want their specific payment term, you want your payment term. If you say, hey, look, let's just take the form agreement out, go back to what the form agreement says, because it's industry standard and everyone kind of agrees it's fair. This is an opportunity where that might come into play and get you some traction. And obviously, both agreements provide for retainage. Unfortunately, now I know the ASA has worked pretty hard on retainage reform, so to the extent you're in one of those jurisdictions where retainage is limited or eliminated by statute, make sure that to the extent you can, you want your contract to actually reflect what the law requires. And then there's interest on late payments under both agreements. Now, I believe that the AIA has a fill point. I'm not sure. I think the ConsensusDocs as well with respect to interest. What the interest will be. What we like to do, rather than putting in a specific percentage, if you're in a jurisdiction where there's a prompt payment statute, and that prompt payment statute, we like to sort of put in the statutory rate, and then that makes sure that you're not limiting whatever your interest would be otherwise under the prompt payment statute by contract. It also is a little bit nice because sometimes that interest only goes one way, or it's different. The subcontractors get more than the contractor would get if you owed them a payment of a back charge or something like that. But so considerations here, we've touched on these. Be aware of pay if paid language, confirm your retainage, and the other thing on retainage, and again, some of you guys may be in jurisdictions where there is no retainage, but and this is really dependent on what type of trade you are. If you're a civil site contractor and you're kind of first on, first off, the trigger for when your retainage is released is probably really important to you, because your retainage could get tied up for years if you agree that retainage will not be released until completion of the project and full acceptance of the work. So you obviously would like to avoid that. So you should try really hard to make your retainage release upon full and final acceptance of your work, not the contractor's work. And just changing one or two words there will make a world of difference for you, because it triggers the release of your retainage when you're done. If you're a fire protection subcontractor and you're kind of last on, last off, release or retainage at project completion is probably not an issue for you, and you're better off picking, and choosing your battles somewhere else in the subcontract. But pay attention to that, and also it's not uncommon to get in there language. We've had good success getting retainage reduced from 10% to 5% and 50% completion of your scope of work, or things like that. So you can get some changes to the retainage section that will be beneficial to you, in my experience. And then the other thing, and this kind of may sound silly, but this is in here for a reason. Under both form contracts, payment is the payment obligation is triggered, or a necessary precondition of payment is issuance of an application for payment. And I can't tell you how many times we've had subcontractors come to us with claims, for retainage or for final payment or for whatever, and we say, okay, well, where's your pay app? And they say, oh, well, we didn't bill for it yet because we're still trying to work out this issue with these change orders. Okay, well, did you bill for the change orders? No. Okay, well, if you haven't applied for payment, arguably under the contract, I mean, maybe it's not even arguably, there's no obligation to pay for the work. So make sure that you're billing for your retainage. Make sure that you're billing for your work, because otherwise, under the contract, there's actually not yet an obligation to pay. So indemnity.
Hey, Mark,
Yes.
this is Ben real quick. I believe at 1230 Ali Sawicki, I apologize if I butchered that name,
Oh, yeah.
asked a question. What's the main difference between pay when paid and pay if paid? I can take a quick shot at that if you don't mind.
Yeah, sure.
So at least in our jurisdiction of Pennsylvania, and obviously all this could be very jurisdiction specific, but in Pennsylvania, pay when paid is a timing mechanism. It's something in your contract that says the contractor will pay the subcontractor when usually within a reasonable period of time after the contractor is paid by the owner. So it's a timing mechanism. And courts have interpreted that. It says even if the owner ends up withholding payment from the contractor, payment will eventually still be due to the subcontractor. The payment from the owner to the contractor is not a condition precedent to the subcontractor being entitled to being paid. Pay, if paid, on the other hand, is a condition precedent, which means that payment will never be due to the subcontractor until the contractor is paid by the owner. So it seems like it's a small difference, but it can make a massive difference in whether payment is even due or as opposed to timing of when it's due. So I hope that answers your question.
Yeah, that's right. So pay when paid, you will eventually get paid, or you should eventually get paid, even if the owner goes bankrupt and never pays the contractor for your work. Pay if paid, if the owner goes bankrupt and never pays the contractor, you're not ever going to have a legal right to payment, or technically you won't have a legal right to payment. Obviously, you've got unjust enrichment, and you may have some other bullets in the gun, so to speak, in terms of ammo to go back at them with, but pay when paid is much better than pay if paid in our jurisdiction, and I think that holds pretty true throughout. So indemnity is an issue that is an area where you'll often see a lot of back and forth, and it's an area where you also really need to know what the laws in your jurisdiction, because in some jurisdictions they have what are referred to as anti-indemnity statutes that make it illegal or void as against public policy for someone to agree, a subcontractor to agree to indemnify the contractor and the owner for damages or claims that arise as a result of the contractor owner's own negligence. So, and that's obviously a really important thing, and that's one of the most important things you want to avoid is if you're not in one of those jurisdictions, you need to make sure that you're not indemnifying others for their own negligence. So let's just kind of walk through this. The indemnity in both agreements is very similar, and this is the biggest area where when we go back and forth with a contractor, where we like to say, look, let's just go back to the industry standard, that the original language in the agreement, it's industry standard, everyone's agreed it's fair, and on top of that, it's one of the benefits of these form contracts is because they're form agreements that many people are using throughout the country, you have a history of, it's been tested by the courts and it's been interpreted by the courts and it's been vetted by the courts, so to speak. So there's a level of comfort with this type of language that you don't have if you're just using some other person's language, whether it be in a form contract that they've modified or whether it be in a new agreement they created from their own agreement that they've just drafted. So in both agreements, the subcontractor shall indemnify and hold harmless indemnified parties. Under both agreements, the indemnified parties are generally going to be the contractor and the design professional and the owner. And now obviously The AIA, they use the term architect. In the consensus docs, they're more accurate and use the term design professional, recognizing you might not have an architect, but instead an engineer or somebody else. And then usually they sweep in agents and employees or consultants and things like that. But you do want to look at, if you are reviewing this section of the agreement, who the indemnified parties are is something you want to keep an eye on. You don't want to be indemnifying every single person that could potentially be involved in the project. You don't want to be indemnifying other subcontractors. Sometimes you might see a lender get thrown in here. I don't know why you would need to indemnify the owner's lender, but things like that. Just understand who are the indemnified parties and be on the lookout for people who don't look like they belong. So then what are you indemnifying from? The key is you want to only, to the extent you can, you want to limit your indemnity obligation to insurable risk. And what's insurable risk? Well, your commercial general liability policy is only going to cover you for bodily injury and property damage claims. And then, so that's what you want to limit indemnity to. Now, there may be other portions in these sections in these agreements where there's other indemnity obligations, for example, for OSHA violations and things like that. That's fine. That's not really what we're talking about in this indemnity section. This indemnity section is really intended to as it's written, to cover the transfer of insurable risk and down to the entity that's responsible for causing that occurrence that gave rise to that claim. So this is all about making sure the party who's responsible and the insurance that party has is going to kick in and cover the claim. And that's the purpose of these. That's why both the AIA and the consensus docs limit the indemnity obligation to insurable risk. And here you see it in the third bullet point for both. Bodily injury, sickness, disease, or death, or injury to or destruction of tangible property other than the work itself in the AIA. That's a long way of saying what they say in the consensus docs, which is bodily injury and property damage other than the work itself. Again, both are just limited to insurable risk. And then the other key is, whose negligent acts are we covering? And both agreements are very clear that the indemnity obligation of the subcontractor is only going to be triggered to the extent caused by the negligent acts or omissions of the subcontractor. Now, consensus docs also throws in intentional wrongful acts. Arguably, your intentional wrongful acts will be outside the bounds of what your insurance will cover. So you might want to strike that language, but it's kind of hard to justify striking it when you go back to the contractor and they're going to say, wait, you're not going to, if you intentionally do something wrong, you're not going to indemnify me from the damages that result. So you're kind of stuck with it if you're in the consensus docs, in my opinion, because you're going to look a little unreasonable if you try to pull it out of there. And frankly, you're going to be, whether it's contractual indemnity or common law indemnity, if you have an intentional wrongful act that causes bodily injury or property damage, you're gonna have an obligation to indemnify either way. So it's not something that is really out of whack or that doesn't necessarily match with what your legal obligations will really be anyway. And then whose acts are you agreeing to indemnify? Again, this is the key. Contractor and owner should never be included in here. You should not be including. You should not be indemnifying for the negligent acts of the contractor or the owner. That, just so people understand, that what that would mean would essentially mean if the contractor, nothing to do with what you're doing on the project, you don't do anything wrong, but if the contractor does something negligent that results in someone getting hurt, the contractor would be able to call on you and say, okay, well, this is your claim. You got to defend and indemnify it and pay it and or otherwise get rid of it or take care of it. Obviously, that's not fair. If the contractor does something to cause and it results in someone getting hurt, the contractor should be responsible for that. Or same thing with the owner. So you should only be indemnifying for subcontractor. You're also, the buck stops with you when it comes to people that are working under you or for you. So you also do indemnify for subcontractors or anyone employed directly or indirectly by them. And then, so understand that, but obviously, but with them, you have an agreement that says, well, to the extent they cause something, they have the obligation to indemnify you. And that's the way it works. It's like links in a chain. Um, the other key aspect here is understanding that in certain jurisdictions, really, I think Texas, maybe Oklahoma, you might see someone take this out entirely and put in what we call knock for knock indemnity. It's a very unique indemnity that seems to be common in the oil and gas industry in those jurisdictions and maybe some others, where basically it's an agreement. Look, if regardless of who causes it, if it's damage to my people or my property, I'm going to indemnify you. And same thing, regardless of who causes it, if it's damage to your people, your property, or what have you, you're going to indemnify me. And it's just a very different way of looking at it. It's something that when we see it, we try to revert back to, the traditional concept of you're indemnifying for your negligence. But understand it's out there, and it's just something that's not necessarily common everywhere. But if you're in one of those jurisdictions, I would recommend you talk to your counsel, who will have their own thoughts on whether or not knock for knock makes sense in your particular situation. So we touched on this. Be aware of the breadth of the indemnity, including the nature of the claims and the parties identified. Be sure to only indemnify for your own negligence, and be aware that some indemnity provisions are unenforceable in certain jurisdictions. So delay and force majeure. These probably in addition to payment, delay seems to be the other area where we have subcontractors come to us most often and tell us they have claims and ask us to help them, and we pull out the contract and we find that we've got a real uphill battle because of the contract language. And the reason for that is in our jurisdiction, and I think in most other jurisdictions, no damage for delay language is valid and enforceable and subject to only certain exceptions. So for those of you who don't know or who are not familiar, no damage for delay language is language that says, to the extent that you're delayed on the project for whatever reason, including reasons that are caused by the contractor or the owner, your sole and exclusive remedy for that delay is an extension of time and an extension of schedule. So the problem is, in the construction business and in pretty much every business, to a certain extent, time is money. So the longer you spend on the project, the more it's going to cost you. If you are delayed and you're sitting idle for days, weeks, or months, that's costing you money. If you are if you're supposed to get a project done in six months and it takes you a year, the fact that you were on that project for an additional 6 months costs you money in a host of different ways. And for none of that to be compensable, and the only thing you get is an extension of the schedule and relief from liquidated damages for that period of time, it's really not coming close to making you whole. And you can get in a situation where if you've agreed to that language and you can't figure out a way to shoehorn your claim and your factual situation into one of the recognized exceptions to the enforceability of no damage for delay in your jurisdiction, if there even are any, you could be stuck where you really don't have a viable claim to recover any of those damages. So the good news is there's no damage for delay language standard in either of these agreements. The bad news is, at least where we practice, it's almost invariable that you're going to see someone put that language in. So you need to understand where it most likely will be, and then also how you could try to get it out. So in the A401, there's no provision regarding delays or force majeure expressly, but there is a section, and this is in Article 5.3, that allows the subcontractor to make claims for extension of time, and this is the key, and damages for delay. So one thing you're going to want to make sure is that and damages for delay has not been stricken, and if it has, how do you get it back in there? In the consensus docs, delays are addressed in Article 5.3 as well, coincidentally, and the subcontractor agrees to initiate all claims for which the owner is or may be liable in the manner and within the time limits provided in the subcontract documents for like claims by constructor upon owner. So again, this is a situation where it's important to understand what's in your prime contract. It's important to know, to have your prime contract so you can go and look at it and see what the timing mechanism is. And then you also may recover for delay damages caused by the contractor, and neither agreement has any express force majeure language. So let's kind of take this all a step back. First of all, there's a distinction between damages. There's three types of delays essentially. I guess four, right? There's delays that are not caused by anybody, like a COVID shutdown, or an act of God, or war, or strike, or things that we would generally consider force majeure. There are then delays that are caused by the owner, and those could be because of not providing site access on time or for anything else the owner might do to delay the project. And then there are also delays that could be originating from and really the fault of the contractor. So you need to figure out how each one of and then the fourth bucket, I guess theoretically, are delays you cause. The bad news is if you cause a delay, that's really nobody's fault but your own. So you're going to be stuck dealing with the consequences of that delay, and you can't push those costs off on anybody else. A contractor caused delay, well, let's take it the other way. So an act of God or force majeure delay, the best scenario is that you have language in your subcontract that says that you're entitled to be paid for delays that are not caused by the subcontractor, or that are not the fault of the subcontractor. So that would sweep all three of those other types of delays, force majeure, owner caused, and contractor caused delays, into one big bucket and make them all compensable. If you cannot get those compensable, all three of those compensable, the most likely situation where you would compromise and agree, well, okay, we'll get no damage for this type of delay, is a force majeure delay, because it's nobody's fault. And it's not uncommon to see force majeure type clauses in agreements, but recognize that that's not your best option. Your best option is to have all delays be compensable as long as they're not caused by you. So a lot of, especially right after COVID, we had contractors calling us up and saying, hey, or subcontractors calling up, you drafted our subcontractor, our contractor, whatever, and there's no force majeure in here. Why not? And it's because we drafted it so force majeures are compensable if they impact you, if the money's flowing down to you. So then with the second type of delay, an owner caused delay, you're typically going to see, and it's usually fair, and we'd recommend you agree to it if you have to, that your remedy for an owner caused delay will be your pro rata share of whatever the contractor is able to recover from the owner for that delay. The risk there is you have to understand whether or not the contractor has already agreed to no damage for delay language in the prime contract, and whether that no damage for delay language will be enforceable in your jurisdiction. So if you know that the contractor struck a bad deal and that with the owner, and they've got no damage for delay, you've got to think long and hard about whether you want to agree to something like something that says that that your damages for delay caused by an owner are going to be limited to whatever the contractor can recover, because that's essentially going to be nothing. So, and I recognize you may not have leverage to change that, but just understand that going in. And then the third type of delay, the contractor caused delay, is something that you need to make sure you're not getting swept up into that second bucket, that owner caused bucket, because contractors will try to kind of throw you a bone in a subcontract with a, no damage for delay, except to the extent that we're able to recover from the owner. Okay, but the problem is, if you, the contractor, caused the delay, you're not going to recover anything from the owner, because the owner doesn't owe you any money for that. So I can't agree to just limit my delay recovery to whatever you recover from the owner. You have to make sure you're carving out that recovery is only for owner caused delays, and if, to the extent a contractor caused a delay, you're entitled to a full equitable adjustment to the contract price to compensate you for all of the reasonable and demonstrable delays that you've encountered, or something like that. The other key here, when you're dealing with delay and with schedule, and these kind of go hand in hand, obviously, is one thing we always really push for, and we generally have some success with, is making sure that you'll almost invariably see the contractor put language in your subcontract that says that they're entitled to change the schedule, and they're entitled to require you to accelerate to meet the schedule, and whatever. And you need to make sure that that you are not being bound. They're entitled to change the schedule, but you're only bound to it to the extent that you've agreed to it. And that kind of ties in, and that you will accelerate to meet the revised schedule, but only to the extent that you've agreed to that schedule, or they agree to compensate you for the acceleration. Kind of getting back to the slide here. So the AAA documents are not very specific on delay, other than saying that you are entitled to make a claim for it. The consensus docs, we've also talked about what they cover here, and the key is under both agreements, you may recover for delay. And making sure that language gets back in there. So be aware of notice requirements, including those contained in the prime contract, and document delays and their causes carefully. This is another really important thing. You often will see language that requires you to present all claims within so many days of the event giving rise to the claim, and that notice must include a quantification of your damages. That's not going to be possible with a delay claim. So keep that in mind, and just make sure that you're documenting and providing the proper notice, and that you keep following up with notice. If the delay is ongoing, you keep following up. I'm still being delayed, and there's no such thing as too much notice. There's definitely such a thing as not enough notice or no notice, and no notice causes a lot of problems once you get to the point where you're actually presenting your claim. For a host of reasons. Not enough notice can cause a lot of problems as well, but I've never had a case where too much notice was a problem. So paper it often and make sure you're following up. Unknown site conditions. This is going to depend, and I'm sorry, I'm running long here. This is going to depend on the type of work you're doing, how important it is. If you're a site contractor and you're dealing with unknown geotechnical conditions, this is going to be really important. If you are it's ground up construction and you're a fire protection contractor, it's probably not going to be as important. The key here is you want to, and we've had a lot of success. You want to make sure that it's addressed exactly what your obligations are to get to the site and understand what's at the site. Are clarified in the contract, and you want to make sure that to the extent you can, you're limiting it to visible and observable conditions, and avoid being responsible for fully investigating and understanding every aspect of the site and the local conditions. Again, visible and observable, and if you can get that, especially if you're doing site work, that's going to be very important for you. Termination. We touched on termination and how important it is to have a right to terminate or suspend as a subcontractor with respect to taking some teeth out of the pay if paid already. Recognize that in the 401 and in the consensus docs, standard is the subcontractor's right to terminate due to non-payment, and in the AIA, this is actually a good right that I like. You can terminate for the same reasons that the contractor may terminate with respect to the owner, which makes sense. And also in the consensus docs, it's a little different. You may terminate for 30 days, after 30 days for non-payment or for unreasonable suspension. So the unreasonable suspension is really important, because that may, even if you have pay if paid, and they could argue, well, your obligation, non-payment's not really going to work here because we never had an obligation to pay you. Unreasonable suspension might be another option. So there's no right of the contractor to terminate for convenience in the standard language of either one of these documents. And recognize that in the A401, in the event the owner terminates the prime contractor for convenience, subcontractor is entitled to payment on work performed, and here's the key, and overhead and profit on work not performed. This is a disconnect between the 401 and the what's in the 201 from 2017, because in the 2017 201 they actually took out the standard language that entitled the contractor to receive overhead and profit on work not performed in the event of termination for convenience. But that's really good language. If you can get that, if you're getting overhead and profit on work not performed, that's really, really nice. In the consensus docs, recognize that if the owner terminates the prime contract, your subcontract recovery is limited, and that wrongful termination by a contractor results in the subcontractor recovering reasonable overhead and profit on the subcontractor work, but not executed as well. So you can get overhead and profit under the consensus docs as well on unperformed work, but you're going to need to establish wrongful termination. But that's still, if you don't think you're being terminated fairly, that gives you a little bit extra to go after in fighting back, and it puts a little bit more risk on the contractor. And recognize they don't have under either one of these the termination for convenience as a escape hatch. So termination considerations: beware of attempts to add termination for convenience language. Beware of attempts to increase the contractor's right to suspend. Be aware of attempts to limit subcontractors' remedies. Be aware of attempts to increase contractors' remedies, and be aware of all notice requirements. The other thing, and this comes up with termination and also with default, we always try to include, and really you should insist, and you can have, we found you get a lot of success and not a lot of pushback on this, a notice, an opportunity to cure. You want at least 5 days written notice, an opportunity to cure before they can just go and terminate you for cause. And same with, any sort of withholding or anything like that. Notice and opportunity to cure is really important. Dispute resolution in the AIAs in Article 3.4 and 3.5, and then claims and disputes are addressed in Article 6, and this all falls under Article 11 of the consensus docs. A couple key points here as we're wrapping up, and I'm sorry I'm going long, but I believe this is the last slide. No, we've got liquidated damages. But so just a couple things. One, there are pros and cons to mediation versus arbitration. There's pros and cons of both. Whether you have a preference for one or for the other, talk to your local attorney about which way they think makes more sense, and if you have a preference, there's nothing wrong with either one. But make sure it's clear. Be careful about the contractor having the right to choose. If they insist on having the right to choose, try to get a mechanism in where you can, you tell them, you give them notice of your claim, and they have to tell you within 10 days what they pick. Otherwise, you get to pick. Be careful about. It's okay, in my opinion, to say that your dispute resolution is going to be whatever is in the prime contract to the extent the claim involves the owner, because that way you can get all the claims together. There's no disconnect. So if you're not forced to arbitrate your claim against the contractor, and the contractor has to pass it through to the owner in litigation or vice versa. Seems to make sense to me. Be very, very careful about a language that says that you are bound to the results or the decision of the dispute resolution between the contractor and the owner, regardless of whether or not you have the opportunity to participate. You never want to be bound to something that you don't have the opportunity to participate in, because you just don't have a seat at the table, and the contractor could be bargaining away or sacrificing your claim to enhance, to better line its pockets with respect to other claims and things like that. So, and you also don't want anything that says that your claim is stayed until the resolution of the contractor's claims against the owner, because you could run into situations where statutes of limitations or mechanics lien statutes or things like that, you run up against them, and you want to be able to advance your claim. You don't want to have to sit back and wait on the sidelines while other people fight things out first. Recognize that under the consensus docs, but not under the AIA agreement, the prevailing party is entitled to attorney's fees and costs for a dispute. To the extent you do have someone put that type of language in the 401, or you see someone change that language, it's really important that it's mutual. You don't want just the contractor being entitled to attorney's fees. You may have statutory right to attorney's fees for under Prompt Payment Acts or something anyway, but still. Just super quick, liquidated damages, obviously understand what they are, understand if the contractor gets its own liquidated damages, make sure that you're pricing the risk for liquidated damages into your agreement to the extent that they are being included. And then the last thing, mutual waiver of consequential damages. There is a mutual waiver in the AIA. It covers everything except for liquidated damages. There is also a mutual waiver in the ConsensusDocs. There's an exception for liquidated damages, and this is important, or other damages that the owner is entitled to recover against the constructor under the prime agreement and for losses covered by insurance. It's this middle part here, or that owner is entitled to recover under against constructor under the prime agreement. So this is another situation where you need to know what your prime agreement says with respect to consequential damages, because you might think, well, we've got a mutual waiver, we're not responsible for consequentials, but there could be a backdoor loophole here to the extent that the contractor did not get that mutual waiver in its contract with the owner. One last thing that's not in these slides, but final thoughts. So here they are. So always be aware of subcontract timing and notice requirements, because if you miss a notice requirement, you could arguably lose your claim. Paper. We talked about that. Make sure that you're providing notice, and there's no such thing as too much notice. And then this last bullet point: an ounce of prevention is worth a pound of cure. You're much better off getting your contract terms right on the front end with respect to delays, payment terms, everything else. Even if it's a fight at the beginning, even if you have to pay an attorney to look at it and you pay him, to negotiate it, that's money well spent, because it not only makes sure that if there is a claim, you've got better terms, but oftentimes it may nip a claim. It may save you from having to present a claim, because the other side's aware, well, this language is not as favorable for us as it normally is. And also we know that they're paying attention to these types of things, and they're sophisticated. So it's worthwhile. Obviously I'm an attorney and this is what I do, but it's worthwhile, I think, money very well spent to get it right on the front end. So with that, I know I went a little bit over. Oh, I see a comment here. Robin Sharp, thoughts on jurisdiction. Yeah, I meant to touch on this. Sorry. A couple things. One, obviously you'd like it to be where you're located, right? But if you can't get that, the fair thing is the location where the project is. That's where most of your witnesses will be. It makes the most sense. And there are many states that have what are called home rule statutes that actually a lot of times go overlooked, but that will say any clause in a contract that requires litigation or arbitration to be subject to the laws of another state, and for a construction project in this state that requires arbitration or litigation to be subject to the laws of another state or to take place in another state are void and against public policy. So I would always push for your jurisdiction, but recognize statutorily there's a good chance that there's a home rule statute that will require it to be in the jurisdiction where the project's located. With all of that said, there are some good arguments under that the Federal Arbitration Act preempts any state statute that would require home rule jurisdiction for construction projects. So if you want to be safe and know for sure, well, we're litigating. If you want to pick a jurisdiction other than the location of the project, you're more likely to have it be enforced if you're in arbitration than litigation, and vice versa. If you don't like the location and you can't get it changed, you're better off pushing for litigation, because you'll have a more likely it's more likely you might be able to get the jurisdictional issue reverted back to the location of the project. Hopefully that answered that. If you'd like to talk more about it, I'm happy to. Again, I'm sorry I went long, but if anyone has any other questions or comments, I'm happy to address them. Oh, thank you.
Okay, thank you.
Thank you.
Thank you, Mark, for your presentation.
Oh,
And go ahead.
oh, that's it.
Okay, wonderful. Okay, with that, we are going to actually, since we are over on time, we're going to go ahead and conclude today. And thank you for your presentation, and thank you for everyone for joining us today. Again, this will be on the ASA online website at the end of the day today, so feel free to check there. You can view the slides and view the presentation again if you would like. And we look forward to you all joining us on our next ASA webinar.
Thank you. Thanks, everyone.
Thank you. Thank you. Bye-bye.